In this video lecture, we're continuing on with land use restrictions. In the last video, we reviewed what a real covenant is. We talked about how there are complex rules at common law for the creation of a real covenant, and we discussed what these requirements are. So now we're going to take a look at a case, Deepwater Brewing, Inc., LLC versus Fairway Resources, Limited, that provides a modern example of what a valid real covenant dispute looks like. And this case is about a view restriction. The facts of the case are as follows. Smith and Alquest, who we'll just refer to as Alquest, owned the Casino del Lago restaurant. And that restaurant had a beautiful view of a lake. And so the key development and its presidents wanted to develop the land between the restaurant and the lake. And they wanted to develop it into a residential subdivision. But in order to develop that land that was in between the restaurant and the lake, they needed access over Alquest's property. And so in 1995, Key Development entered into two agreements with Alquest. And the first was that Alquest agreed to grant an easement for the subdivision so that Key Development could build the residential community. And in the second agreement, Key Development agreed that any new houses that were built in this residential subdivision would not block the lake view that KeyQuest had. So Johnson, the president of Key Development, recorded the restrictive covenant which encumbered the subdivision and prevented them from blocking the view. One of these covenants imposed a 16-foot height limit, and that was the limit that was used to prevent blocking the view, 16 feet. In 1998, the Kennedys purchased the restaurant from Alquest. They knew about both agreements, about the easement and about the real covenant. Well, in 2000, Mr. Kennedy leased the building to his business, Deepwater Brewing. So that's how Deepwater Brewing is a party. Well, in 2000, the covenants that were affecting the residential buildings were amended by Key Development to allow buildings up to 26 feet. Now that would end up blocking the view. So in 2000, Deepwater sued Key Development. And by the time the case went to trial, there were already several houses that were built that blocked the view. So in this photo here, as you can see in the slide, you can see how the houses were built to block the view. So the trial court awarded $245,000 in damages against Key Development. The Court of Appeals upheld this decision based on the theory that the 1995 promise not to block the view was a real covenant, and that the benefit ran to the Kangys, the owners of Deepwater Brewing, from Kangy to Alquest. To Kangys as the successors of Alquest, right? So here, let me give you a diagram that makes this a little bit clearer. All right, so as you can see here, back we go. as you can see here, we have the burden side. It's always useful to diagram these when you have fact patterns like this. So you have the burden side and you have the benefit side here. And for the burden side, that's key development, right? Because they are the ones who are burdened with not building. They're the ones who are supposed to restrict their behavior. And the Alquests were benefiting from that covenant. So they're on the benefit side. So there is horizontal privity between the Alquests and key development because they were the original parties. And there was an easement between Alquest and key development, if you might remember. So there's also vertical privity here because the Alquests were grantors to Kinnegees. So there's vertical privity here. So those two requirements were met. So the rule the court applied was that under Washington law, there's actually 5 requirements. So the first 2 are on this slide, the last 3 are on the next slide. So let's go through them. The first is that the covenant must have been enforceable between the original parties, such enforceability being a question of contract law, except insofar as the covenant must satisfy the statute of frauds. Do we have that element? Well, yes, the covenant was enforceable to the original parties, right? And it was in writing. So we satisfied the statute of frauds. So we can check that off. Then let's go to the second one. The covenant to touch and concern both the land to be benefited and the land to be burdened. So the covenant touches and concerns land if it is connected with the use and enjoyment of the land. And you can see that when restrictions on one land are used to benefit another. And we said earlier that a promise to do or to refrain from doing a physical act is almost always found to touch and concern the land. So in this case, we have a restriction on not building, and so that would touch and concern the land. So we can check off number 2. Let's take a look at the remaining 3 elements. So the third element was the covenanting party must have intended to bind their successors in interest. In interpreting the third element, the court states that generally they would require some expression of intent to assign the burden to the successors. But here, intent may be drawn from all of the language, including the nature of the covenant. So, although they did not expressly state their intent to bind successors, the court found that the nature of the covenant itself demonstrated that there was an intent to bind the successors. So they found that element 3 had been met. Element 4 was looking, element 4 and 5. So 4 was looking for vertical privity of estate, and 5 was looking for horizontal privity of estate, or privity between the parties. The court found that the requirements for both vertical and horizontal privity were met, and that is because for vertical privity, we have the Kinnegees purchased from Alquest. So if we go back to this diagram here, we see vertical privity is met, and horizontal privity is met here as well, because key development was an original party to both agreements. And so all the elements were met, and a valid covenant was found, and so they affirmed the judgment for the lower court. Also, just a quick note before I move on horizontal privity. There are three approaches to horizontal privity, right? The mutual interest, successive interest, or no requirement. The Washington court uses the successive interest approach. And if you look at page 744, they say that this requires the transfer of some interest in land other than the covenant itself between the covenanter and the covenantee in connection with the making of the covenant. And here, because Alvinus conveyed the easement to Key Development, which was a transfer of interest in land, remember the right-of-way, that easement, that meets the horizontal privity element. Now, also, you might notice that the court didn't discuss the element of notice, right? Notice wasn't listed as an element. Why do you think that was? The reason the notice element was not mentioned was because this case only involves the benefit side of the covenant, right? Because those who are suing are on the benefit side. And those who receive the benefit are not required to have notice for that benefit to run. Remember, notice is only required for a burden to run to the successor. And we talked about why that was. All right, I know that the touch and concern element is a bit difficult. And so let's just do a quick hypothetical to see if you understand it. So let's suppose that Key Development also agreed not to operate a restaurant within the subdivision. Would this touch and concern the land? The answer is yes. So the reason that it touches and concerns the land is because it restricts the use of the burdened land. And we said that restrictions on the burdened land are typically found to touch and concern it. So they restrict the use of the burdened land by requiring that no restaurant be built there, and they enhance the benefited land, and that would be theoretically so that there would be less competition. All right, so now we're going to move on to our next topic, which is equitable servitude. Equitable servitudes are private agreements that are usually contained in a deed or lease, and they restrict the use or occupancy of real property. Some things that they commonly do are specifying lot size, building lines, architectural style, and the uses that the property can be put to. Equitable servitudes, the difference between an equitable servitude and a real covenant, one of which is the type of remedy available. With a real covenant, the type of remedy available is money damages. And so to get that remedy, the plaintiff would have to show that there were some actual damages that occurred because of the breach of the covenant. Now, the remedy available for a breach of an equitable servitude is injunctive relief, meaning that the court will come in and stop the party from doing something typically. Okay, so equitable servitudes are easier to prove than real covenants because they have less elements, but they also provide for injunctive relief. So that might be the reason why a party decides to seek a claim under equitable servitude versus real covenants. So let's take a look at the requirement for an equitable servitude. For the burden to run and for the benefit to run, there are different requirements similar to a real covenant. And just similar to a real covenant, the requirements for a burden to run are greater than the requirements or the elements for a benefit to run. So both of them require the first element, which is that the statute of frauds needs to have been complied with. Either the agreement needs to be in writing, or there needs to be what is called a common plan, where there's a developer of the land and that developer decides that they have a common plan, and that common plan is a written plan of what the properties must look like, or the restrictions that they must comply to. For both a burden and a benefit to run, there must be intent to bind the successors. Again, that's similar to a real covenant. For both to run, the restriction must touch and concern the land. Now, here there's a difference again with a notice requirement. For a burden to run, the party that is to be burdened has to have notice of the burden. But for the benefit to run, the party that benefits does not have to have notice of the equitable servitude. And it's the same reasons that I gave you for the real covenant. Now, what specifically makes an equitable servitude easier to prove than a real covenant is that the elements of horizontal privity and vertical privity are not required for the burden to run, whereas they are required for a real covenant for the burden to run. So that's one of the primary differences. And we said the remedy that's available is also another difference. The next case we're going to discuss, Gambrell v. Nivens. It is an example of a valid equitable servitude that restricted use of a property to only residential use. And the defendants in the case had built a wedding chapel, which was a commercial use. Let's discuss the facts. The facts of the case, here we go. The facts of the case are as follows. The Gambrells bought a large piece of rural land that they subdivided into four lots. They sold 3 of them and they kept 1 of them. When they sold the lots, they placed restrictions on the lots that included a provision that said that no lot shall be used except for residential purposes. The Fauchys purchased 1 lot. They later conveyed it to the Nivenses. The Nivenses, they began building a wedding chapel on it. And so the Gambrells sued the Nivenses, seeking an injunction to prevent them from finishing the construction of the church. They alleged that the lot was being used for commercial purposes, which violated the restriction. The trial court issued a permanent injunction, and the Court of Appeals here, in this case, affirmed. So this dispute is about a restriction, right? And it was placed on a lot for non-residential building. And the Gambrells sued under the doctrine of equitable servitude. Now, why do you think they sued under the doctrine of equitable servitude and not under the not seeking to enforce the restriction as a real covenant? Well, we did say that real covenants are a little bit harder to prove, right? Because there is that requirement for horizontal and vertical privity. And we haven't gone through an analysis of the facts yet, but they likely would have been able to meet both horizontal and vertical privity requirements. So the reason that Gambrell sued under equitable servitude was because they were looking to seek an injunction. They were looking to prevent the Nivenses from building. And remember, we said that equitable servitude, the remedy for an equitable servitude is an injunction. Another reason they may not have sued sued to enforce the restriction as a real covenant could have been because it was hard for them to prove damages. Because remember, the remedy for a real covenant are money damages. And it may have been difficult for them to prove damages because perhaps a church being built on that lot may not have decreased the property values, right? So either way, that's most likely the reason that they used the equitable servitudes doctrine. So let's look at the rules that the court stated apply. When in order to enforce a promise as a equitable servitude, you must have typically 4 elements, but for some reason this court only included 3 of them and assumed the 4th. You should know that there are 4 elements. So this court included the element to touch and concern the land, that the original parties to the covenant must intend that it run with the land and bind remote guarantees, so the intent requirement, and that remote guarantees must have had notice of the covenant. What is the element that the court failed to explicitly name? And go back and look at the list of elements we discussed earlier. The 4th element is that the covenant or the promise must be in writing or implied by the common plan. Now here we had a common plan, and so it was that may be why the court didn't explicitly name it. But you should know that for exam purposes, there are 4 elements. So here's the slide that says the 4th element is also needed. It must be in writing or implied from a common plan. All right. So before we get into these exercises, let's first apply the rules to the facts of the case. Apologies. There we go. So it must concern or touch the land. Did it concern or touch the land? Yes, it did. It touched and concerned the land because it was a restriction on the use of the land. And we said restrictions on the use of the land are almost always found to be touching and concerning the land, right? All right, what about the next element? Was there intent for the covenant to bind future successors? The answer is yes. Actually, it was expressly included in the language of the attachment that the parties intended the covenant to run with the land and bind successors. Finally, did the remote grantees have notice? Did the Nivenses have notice of the covenant? And the answer is yes. They actually had actual notice. So the real estate agent testified that they gave them a copy of the covenants prior to the purchase. So it was actual notice. But remember, there are 3 types of notice. We can have actual notice, record notice, or implied notice. And here we have actual notice because they received a copy of the covenants. They don't have to actually have read it. It's sufficient that they just received it. Now note the court doesn't rely on record notice, and that's because under state law, the covenants were not properly recorded. And they weren't properly recorded because you may remember from the principles of contracts that there was this doctrine of incorporation where you could incorporate other documents into the contract by reference. Well, the court notes that the deed did not contain a reference to the attachment. It was just a separate paper that was put with the deed, and as such, it was not valid, right? Okay, so, and we said the fourth element was met because it was in the common plan, right? So all the elements have been met. And so the court found for the Gambrells, and they instituted, or they kept the permanent injunction. So let's do some exercises to see if we really understand what an equitable servitude is. And let's also compare that with real covenants. So the question is, can these restrictions be enforced as equitable servitudes or as real covenants? So A and B own adjacent vacant lots in a residential subdivision. They enter into a written agreement promising on behalf of ourselves and our successors that no structure higher than 30 feet may be built on either lot. They sign and record the agreement. B sells her lot to C, who now plans to build a house that will be 35 feet high. A sues C. Can these restrictions be enforced as an equitable servitude? Let's start there. All right, first the best way to approach these questions is to first ask yourself, are we looking to enforce the benefit or the burden? And so in this case, A is suing C to enforce the burden, right? So we're looking over under the column here for burden to run. So has the first element been met? Is it in writing or a common plan? The answer is yes. The facts say that it was a written agreement. Also, just as a heads up, if you turn to page 750 of your book, you will find the questions so you can follow along with the fact pattern. So it's on page 750. Okay, so first element met. Second element, is there intent to bind the successors? Well, yes, because it says explicitly in the agreement on our behalf of ourselves and our successors. Does it touch and concern the land? Yes, because any restrictions on the use of land are considered to touch and concern. Is there notice? Yes, there is notice, right? Because the agreement has been recorded. So there will be record notice. So A should be successful in enforcing the agreement as an equitable servitude. And in doing so, they can seek an injunction to stop C from building the house at 35 feet high. Okay, so let's now go back to that fact pattern and answer the question, can A sue to enforce the agreement as a real covenant? Here are the elements for a real covenant. So we've already discussed these first four elements, right? So we're looking to see if the burden runs. We've already discussed these first four elements. So what we need to decide is if there's horizontal privity and if there's vertical privity, because the fact pattern didn't state whether this jurisdiction requires vertical privity or not. So you are going to apply vertical privity and say that although most jurisdictions do not require vertical privity. Some do, and so you need to still analyze the vertical privity requirement. Okay. So is there horizontal privity? Well, no, there isn't. Why is there not horizontal privity? Well, we said that for horizontal privity, there are 3 different approaches, right? We can have the mutual interest approach, successive interests, or 3, it doesn't apply, but in this case, we're going to assume it applies. So the original parties to the promise did not have mutual interests. They didn't share an easement or any interest in the land that was conveyed from, and there was no interest that was conveyed from one of them to the other. So they didn't share mutual interest or successive interests. So in this fact pattern, A would not be able to enforce the agreement as a real covenant. So what about vertical privity? There would be vertical privity here, and you would still want to analyze that even if you find that one of the elements fail. It's always good practice to continue on with the remaining elements. And so, yes, vertical privity here would be found. Why? Because all of the interest was transferred from B to C, and that's what's required for vertical privity. All right, let's move on to the next hypothetical. Again, you can find this on page 750 of your book. D and E purchased homes in a 20-lot subdivision. D's property and 16 of the other lots contain express restrictions in their chain of title that all houses in the subdivision must be painted in earth tones such as beige or brown. That restriction, though, is not in E's chain of title. Okay, so it's in 16 of the other lots, but it's not in the chain of title for E's house. All houses in the subdivision are actually painted beige or brown. And E now leases her property to F for a 99-year term without telling her about the restriction. F plans to paint the house bright blue. D sues F. Okay, let's first analyze whether or not D can sue to enforce the restriction as an equitable servitude. Okay, here are the elements. Let's go through them. So do we satisfy the statute of frauds requirement? We do, because there was a common plan. So even though it does not expressly state that it was in writing, there was a common plan. Let me define common plan expressly for you, because I don't think I have done that yet. From Black's Law's dictionary, so it defines a common plan as the general design or layout of plots of land surrounding a particular tract. It's a general design or layout of plots of land surrounding a particular tract. So here we would have a general design, right? And it is clear that at least 17 of the 20 lots are expressly burned, right, because it's in their chain of title. So here a common plan would likely be found. That would meet element A. Second element, intent to bind successors. Well, this is actually pretty thin here. You could make an argument that there wasn't intent to bind successors, but the existence of a common plan seems to manifest that intent. Because why would a common plan be instituted if they didn't intend to bind successors? What would be the purpose of trying to have uniformity amongst houses if when one person sold the house, the successor wouldn't have to stick with that uniformity? So it is likely that a court would still infer the intent to bind successors because the common plan is present. Okay, what about touching and concerning? Again, here we've met that element because there's a restriction on what can be done to the land or how the land can be used. So it'll be found to touch and concern the land. What about, we forgot to do the first step, which was to decide whether or not we're seeking to enforce the burden or the benefit. And we're seeking to enforce the burden again. And as a result, we have to discuss notice. So both E and F probably have inquiry notice because most of the houses in the homes are painted the same color. And so they had reason or put on notice that they should have inquired further. And so inquiry notice would have likely been met. The idea is that a reasonable person would have inquired further or would have suspected that there was some type of common plan because every house in the subdivision is the same color. So inquiry notice would likely have been met. Therefore, we would, D would likely be able to enforce the promise against F. Okay. What about a real covenant? Would D have been able to enforce the restriction as a real covenant? So first we would need to ask, are we seeking to enforce the burden or the benefit? We're seeking to enforce the burden, right? We're seeking to enforce the restriction. I made a slight misstatement in the last analysis for the last hypothetical. We actually can't assume that the first four elements have been met because they're not exactly the same. The difference between the first requirement, there is a difference in the first element between real covenants and equitable servitudes, and my apologies for not stating it earlier, and that is that a common plan is not sufficient to meet the statute of frauds requirement, whereas it is sufficient to meet the requirement for equitable servitude. So please make that distinction, because in this hypothetical, the real covenant is not going to burden F because the restriction is not in a writing that satisfies the statute of fraud. So we don't satisfy this first element here. Because yes, there is a common plan, but that common plan is not sufficient to satisfy the statute of frauds. To satisfy the statute of frauds, that restriction would have also have had to be in E's deed, written in E's deed, and then it would have been enforceable. Now, just for fun, let's think real quick about whether or not there's horizontal privity. There may actually be horizontal privity here in that E and E's grantor had successive interests. Right? So E and E's grantor had successive interests in this case. And so there might be horizontal privity here where the jurisdiction uses a successive interest or recognizes successive interests as meeting that horizontal privity requirement. So now I'd like to quickly discuss the restatement approach. So we've been discussing the common law approach to real covenants and equitable servitude. But the restatement approach is different. The restatement combines real covenants and equitable servitude, and they create something called a servitude. A servitude is a covenant that runs at law. And what it does is the restatement felt that, the authors of the restatement felt that there really wasn't much of a distinction anymore between real covenants and equitable servitudes. And so they combined them into a new type of covenant that's called a servitude. So what differs, there's a few differences, right? So the first is that this standard, we're going to see as we go through it, it abandons the requirement that the covenant touch and concern the land. So that's no longer an element. And there's no longer the need for horizontal privity. Now, there also isn't a need for vertical privity. But that is only as applied to a negative covenant. If it is an affirmative covenant, there may be a requirement of vertical privity. Now, I am not going to test you on those distinctions, but I just want to note that they exist. All right. Something else we're going to notice is that there is not a requirement that there is notice to successors. But the restatement allows for a defense to the enforcement of a servitude, and lack of notice provides a defense against its enforcement. So even if you have a valid servitude, lack of defense can be raised as a defense and prevent the servitude's enforcement. So let's go through these elements. The first is that a servitude arises when the owner of the property to be burdened intends to create a servitude. So we have the owner who is burdened has to intend to create the servitude. The owner enters into a contract or conveyance to this effect that satisfies the statute of frauds. So statute of frauds is a requirement. Satisfying statute of frauds is a requirement. And the servitude cannot be arbitrary, unconstitutional, unconscionable, or violative of certain public policies. For example, it can't unreasonably restrain alienation. So let's go back to our hypotheticals that we just did. And I'd like you to tell me, for this first fact pattern here, could it be enforced as a servitude under the restatement approach? Could it be enforced as a servitude under the restatement approach? Well, to answer the question, let's look at the elements. So did the owner of the property to be burdened intend to create a servitude? And the answer is yes. Actually, both A and B intended to create a servitude. They had a written agreement, and that written agreement imposed the height restriction, right? All right. Did the owner of the property enter into a contract or conveyance that satisfies the statute of frauds? The answer here is yes. Right? They had a written agreement that imposed the height restriction. We assume that it satisfies the statute of frauds recommendation or requirement. And then the third, was the servitude arbitrary, unconstitutional, unconscionable, or violative of certain public policies? It is not, right? So we meet that element. Why? Because there are plenty of legitimate purposes for height restrictions. So they're not arbitrary, right? They could protect views. And And so we've met all of the elements for a servitude. There is a servitude here. You still want to make sure you ask the question of whether or not C had record notice, because remember, C could raise a defense against enforcement by saying they didn't have record notice of the servitude. But C here does have notice. They have record notice. So all of the elements will have been met. We have a servitude, and that servitude will likely be enforceable. All right, let's go back to the second problem. Oops. And on page 750. This is where D&E purchased the home in a 20-lot subdivision. D's property and 16 of the other lots contained express restrictions in their chain of title that all houses in the subdivision must be painted in earth tones such as beige or brown, but the restriction is not in E's chain of title. All houses in the subdivision are painted beige or brown. E now leases her property to F for a 99-year term without telling her about the restriction. F plans to paint the house bright blue. D sues F. Could D claim a servitude under the restatement definition? So this answer is not as clear-cut. The authors of your book argue that it is probably a valid restriction here, and it would be valid under servitude. Admittedly, though, the restatement standards don't apply very neatly here, right? There is no document that satisfies the statute of frauds. And it's not really clear that the subdivider intended to burden E's lot. But, and again, you wouldn't have known this. It was still good for you to go through the steps of applying it, but you would have known that the restatement does have a provision that says that a conveyance by a developer that imposes a servitude on the land conveyed to implement a general plan creates an implied reciprocal servitude burdening all of the developer's remaining land included in the general plan, if injustice can be avoided only by implying the reciprocal servitude. So here in the fact patterns, the paint color restriction burdens 17 of the 20 lots. And so unless there is some substantial reason for not burdening the remaining 3 lots, this suggests that the developer had intended in the general plan to burden all of the lots in the subdivision. So as long as, quote, injustice could be avoided, then likely the elements would have been met. So there was intent, and the common plan would justify the statute of frauds requirement here. And the servitude is not arbitrary, right? And we presume that E and F here would be also on inquiry notice, right? For the same reasons that we said they would be on inquiry notice for the others, for the other questions. All right, so we're going to stop here, and we're going to pick up next with C, C, and R's.